items of the day.
Ballot item number 48, Order M213, second reading of Bill 213, an act to amend the Highway Traffic Act with respect to careless driving causing death or bodily harm. Ms. McMahon.
The member from Burlington.
Thank you, Madam Speaker. I move second reading of Bill 213, an act to amend the Highway Traffic Act with respect to careless driving causing death or bodily harm.
Ms. McMahon has moved second reading of Bill 213. Pursuant to Standing Order 98, the member has 12 minutes for her presentation.
Thank you, Madam Speaker. I'm pleased to begin debate on Bill 213. In doing so, I want to recognize a number of colleagues, friends, and family who come to Queen's Park today in support of today's debate. They are my brother, Ed McMahon, Constable Hugh Smith from the Toronto Police Service, from the Ontario Provincial Police Association, Chris Hoffman, from the Police Association of Ontario, Stephen Reed and Bruce Chapman, Jamie Stuckless, Executive Director of the Share the Road Cycling Coalition, and Share the Road Board Member Ian Brisman, a lawyer from Hamilton. Thank you all for being here. Speaker, 10 years ago this week, my life and the lives of many people dear to me changed forever when a careless driver struck and killed my husband, OPP Sergeant Greg Staubert, a veteran police officer in his 25th year of service. Greg was killed while on a training ride in Milton. He was 44 years old and in the prime of his life. As many of my honourable colleagues in this House know, Greg's death and his life's work as an OPP officer have been the impetus for the direction I've taken in my life over the past decade. It has shaped my approach to and my decisions regarding advocacy and my decision to fight for changes to legislative constructs, enhanced infrastructure funding, and education and awareness for motorists and cyclists when it comes to sharing the road, all in the interest of road safety. Our response to this tragic loss was, in 2008, making the case for legislative changes that would enhance road safety by providing frontline law enforcement with the tools they need to reduce the number of motorists who continue to drive under suspension. This was in response to Greg's case, but also to the estimated 500,000 suspended drivers in Ontario, with an estimated 3/4 of these people continuing to drive despite their suspension. Greg's law provided for enhanced penalties for motorists who drive under suspension in the hopes of reducing repeat offenders and in the hopes of reducing the number of uninsured drivers and getting them off the road. It passed in 2009 and came into force in 2010. In 2008, we started the Share the Road Cycling Coalition, a provincial cycling advocacy organization with a mandate to bring about legislative change in Ontario that would enhance road safety, empower municipalities to make their communities more bicycle-friendly, change the conversation, enhance education and awareness of the importance of sharing the road, reminding people that whether you're a driver, a cyclist, or a pedestrian, we all have responsibilities when we're on the road. During my time at the Coalition, I'm proud to say that, working together with many members of this House, we made tremendous progress for cyclists and indeed all vulnerable road users. This progress included the first provincial infrastructure program for cycling, with $25 million in dedicated funding for projects that are now being built in communities across Ontario. We drove major changes to the Highway Traffic Act, including a 1-metre safe passing law, the second in Canada, as part of the most significant update to the Highway Traffic Act for cycling in our province's history, Bill 31 in 2015. A provincial investment in cycling education programs was another major and very recent step forward. All of these were recommendations of the 2012 Ontario Coroner's Review into Cycling Deaths, and I was honoured to sit as a member of that review. All of this is Greg's legacy. And while I'm tremendously proud of what's been accomplished, at the end of the day, like all of the 129 cyclists that were part of the Coroner's Death Review, like the hundreds of Ontarians who die on our roads each year, Greg's death was preventable. The driver who killed Greg had 5 previous convictions of driving with a suspended license, 2 convictions of driving with no insurance, and had collected $15,000 in traffic-related fines. His sentence, his license was suspended again, and he received 100 hours of community service. And just 62 days after this man hit Greg, he hit someone else. One of the conclusions to be drawn from this is that despite his actions, despite the fact that he killed someone as a result of his carelessness, he continued to drive without the kind of due care and attention which is the minimum standard expected of all of us, and which the Careless Driving Statute, Section 130 of the Highway Traffic Act, which I hope to amend today, Speaker, demands. Tragically, Greg's story is yet unique. Every year in Ontario, lives are taken because another individual made a bad choice. In 2015, in the City of Toronto alone, 64 people died in traffic fatalities. This is up from 35 in 2011 and 51 in 2014. And so in 6 years, the number of lives lost, all of them preventable, has nearly doubled. Of these, 38 were pedestrians and 4 were cyclists, meaning that 67% of these were vulnerable road users. And I'm willing to bet, although statistics are not kept in this regard, that a good chunk of those led to charges of careless driving and to outcomes for all concerned, the victims, their families, the police officers laying the charge, that were less than satisfactory from the perspective of some kind of assurance that the penalties associated with the outcomes were sufficient. Of course, when you lose someone you love, like I did, nothing's going to bring them back, and nothing will feel sufficient. But of this I am sure, that the current statute, which lacks the kind of specificity both in terms of the charge and the sentence provisions, is calling out for reform. Carelessness is the cause of most deaths that result from vehicle-related deaths. By the year 2020, it is estimated that road traffic injuries will become the third greatest contributor to the global burden of disease and injury. These kinds of injuries and fatalities are preventable. In fact, according to the 2012 Chief Coroner's report that I mentioned earlier, of the 129 deaths reviewed, 100% of them were preventable. Because all drivers make choices, whether it's choosing to text and drive, choosing to get behind the wheel after a few beers, or instead choosing to concentrate on the task at hand, focusing on the road and arriving at their destination safely. A police officer friend of mine said once, sometimes there are just accidents, Eleanor. Fair enough. But if your poor choice results in injury or the death of another human being, if you are inattentive behind the wheel, even for a moment, if your carelessness and disregard for others leads to these results, if Bill 213 passes, the penalties you will pay are significant. By contrast, the person who is the victim of your carelessness, who may be seriously injured, will face a life of difficult challenges, and so will their family. And if you kill them, then the sentence that you will have imposed is a life sentence, as I know only too well. As police officers know, it's unlikely that these types of collisions, including those causing death, will result in criminal charges and the stiffer penalties that come with federal statutes. Indeed, most will result in a traffic violation under the Highway Traffic Act. It's far too common for drivers who have caused the death of another human being to see penalties as simple as a fine of a few $100s, demerit points, or a suspended driver's license. Worse still, as happens so often with traffic offences, a plea bargaining process ensues with a lesser sentence often applied. And so if we provide officers with the tools they need to lay a charge which speaks to the behaviour of the motorist as well as the outcome, and if we provide the courts with great specificity when it comes to sentencing options with the full force of the highest penalties allowed under provincial statute, then we are sending a clear signal to all Ontarians that driving is a privilege and not a right. That driving carelessly is serious and that lives matter, especially when the family of the victim serves a life sentence of grief. For repeat offenders, the current penalties run the risk of continuing to have little deterrent effect. I've seen that firsthand. Under the Highway Traffic Act, careless driving is one of the most serious offences. It is defined as driving without due care and attention. In order to charge a driver under the criminal code, there would need to be established an intent to kill or cause bodily harm, or the driver in question would have had to be so outrageously dangerous that the driver would have known that killing someone was a likely outcome. Our legal system requires proof beyond a reasonable doubt in order to convict someone of a criminal charge, and for good reason. It's an important pillar of our justice system. But in cases of careless driving that cause death, unfortunately that means that most of these drivers are charged under the Highway Traffic Act when the driver's actions are under scrutiny, not the fact that an innocent person was seriously killed or injured. Personal injury lawyer Patrick Brown, a colleague with whom I called for a review of cycling deaths by the Ontario coroner, and with whom I served on that review, recently noted that of the cases studied in the review, charges were laid in only 30% of the cases, with 19% of them under the Highway Traffic Act and 11 under the Criminal Code. Now, I'm not advocating that all motorists should be charged and penalized as criminals, but I do believe that we need to encourage safe driving and deter careless driving, so that preventable deaths are just that, preventable. And so there's clearly a gap between careless driving and the criminal offence of dangerous driving or criminal negligence. Bill 213 seeks to close that gap. Currently, under the Highway Traffic Act, the minimum fine for careless driving is $400, the maximum $2,000. Drivers could face up to 6 demerit points, license suspension of up to 2 years, and to 6 months in prison, although this is rarely, if ever, delivered as a sentence. Indeed, a friend of mine, a member of the Toronto Police Service with 29 years of service, told me recently that in all his years on the job, most of them in traffic, with all of the careless driving charges he's laid, none of them has resulted in a jail sentence, despite the fact that people have died as a result of the carelessness of a motorist. To him and to all the officers across Ontario who serve our province, who work so diligently to keep our roads safe every day, I say this. In Greg's memory and in memory of all those whose lives have been lost, for all the accident and collision reconstructionists, The guys and gals patrolling our roads and provincial highways, today's bill is for you. Greg's frustration with the lack of specificity inherent in Section 130, his frustration at his inability to lay a charge which fit the offence, was something I heard about very often. Today we are changing the conversation about what careless driving should mean. This bill aims to fill the gap between less and more severe offences, providing additional charging options to both law enforcement and our courts. It aims to recognize and provide a tool for collisions that result in serious injury or death by creating a separate offence of careless driving caused death or bodily harm. Bill 213, if passed, would increase penalties under this new category, making a clear distinction between careless driving and careless driving causing death and bodily harm. It will also give police officers more time to conduct an investigation, and collision reconstructionists the time they need to do these often painstaking investigations. Under the proposed new category, fines would be a minimum of $2,000 to a maximum of $50,000. The driver could face a maximum of 2 years in prison, the maximum allowed under provincial statute, as opposed to the current maximum for careless, which is 6 months. Their driver's license could be suspended for up to 5 years. Their sentencing options will include the requirement to complete a road safety or a driver training course as well. Ultimately, the goal is to have penalties in place that discourage careless driving and encourage good choices behind the wheel. But we will also use this opportunity to help promote public awareness of the threat posed by motor vehicles in the hands of the wrong person. And finally, we will draw attention to the fact that when a motorist is careless and hits a cyclist or a pedestrian, the outcomes are much more significant. And with Bill 213, both our officers and our courts will have the opportunity to send that very clear signal that driving with due care and attention matters, arguably more so, when it comes to our most vulnerable road users. In closing, Mr. Speaker, I want to thank all of my colleagues on all sides of the House for their support for road safety, for community safety, most of all for their support for cycling, and all of our combined efforts to make sharing the road easier and safer for all Ontarians. To my family, to my policing family, it is my privilege to table this law on your behalf. And to Greg, wherever you are. Sorry, Madam Speaker. I hope the skies are blue, the road ahead is clear, and that you are pedaling with all of the joy, the enthusiasm, and the love of life that was so emblematic to everything that you were and that you meant to all of us. Thank you, Madam Speaker. Ride on in the knowledge that we are working hard to make the roads safer in your name. Thank you, Madam Speaker.